wanted to discuss some of the court decisions in California dealing with our single subject rule. In Article 4, Section 9 provides that a statute shall embrace but one subject which shall be expressed in its title. So this is the single subject rule for bills. There's also a separate single subject rule for initiatives. And here the Cal Supreme Court case said in Harbor versus Deukmejian in 1987, the constitutional provision contains two independent aspects which serve separate purposes. A statute must comply with both the requirement that it be confined to one subject and with the command that this one subject be expressed in its title. The court in Harbor versus Deukmejian also said, the single subject clause has as its primary and universally recognized purpose the prevention of log rolling by the legislature, that is, combining several proposals in a single bill so that legislators, by combining their votes, obtain a majority for a measure which would not have been approved if divided into separate bills. The California Court of Appeal in Planned Parenthood Affiliates versus Swope in 1985 said, the purpose of the title clause is to prevent legislators and the public from being entrapped by misleading titles to bills, whereby legislation relating to one subject might be obtained under the title of another. And the court in Planned Parenthood also said, to minimize judicial interference in legislative branch activities, courts must construe the single subject rule liberally. The rule is not designed as a loophole of escape from or a means for the destruction of legitimate legislation. In the Planned Parenthood, the Court of Appeal also said, a measure complies with the rule if its provisions are either functionally related to one another or are reasonably germane to one another or the objects of the enactment. However, numerous the provisions of any act may be, if they can be fairly considered as falling within the subject matter of legislation or as proper methods for the attainment of the end sought by the act, there is no conflict with the constitutional provision. The Court of Appeal also said in Planned Parenthood, a provision is deemed germane if it's auxiliary to and promotive of the main purpose of the act or has a necessary and natural connection with that purpose. The title of an act defines the subject to which the substance of its provisions must be germane. Turning back to Harbor versus Deukmejian, the California Supreme Court also said, the legislation that was enacted 10 days after the budget and was described as a trailer bill which trails the budget and is closely related to it is proper. The petitioner suggested that the subject of the bill was fiscal affairs, as stated in its title, and its object was to make statutory adjustments which relate to the ongoing allocation of state funds appropriated annually in the budget bill. This bill amended, repealed, or added approximately 150 sections contained in more than 20 codes and legislative acts, which is why it was struck down by the Supreme Court. And finally, in People versus Wallace, a 2004 California appellate court decision on trailer bills, the court said, trailer bills are generally separated by subject area such as education, resources, or health to minimize possible conflicts with single subject limitations that could occur if a general omnibus trailer bill were to be proposed. In other words, the trailer bill is not part of the Budget Act. It is separate and remains subject to a veto.